compliance initiatives, et cetera. So before I sort of start to dive in, does anybody have anything, any questions or anything that they'd like to talk about? Any burning desires of where they'd like the discussion to go? No? Okay. All right. I'm just checking again to make sure everybody, I think all the recorders, I let them all in. Is it working?
Yeah, we're good there.
Okay,
Yeah,
great.
I mean, yeah, I'll leave it to you also to bring up topics. I definitely don't know the lay of the land in terms of new regulations coming out for AI. I have not been paying close enough attention to really understand even how to address or talk about this stuff. So I'm here to learn a little bit and hear from people who actually have taken time to understand what's going on. So whoever feels like they are an up and coming expert in this field, please feel free to chime in.
Great. Thanks, Brian. Well, I know I've talked one-on-one or in small groups with a bunch of you, and I think the best way I can equate this is I feel like it's 2017 again. 2017 pre-GDPR, when every attorney in sort of big law practice was like, yes, we'll help advise you on GDPR, but they knew about as much as the in-house attorneys did, and it wasn't super helpful. Nobody understood the difference between a controller, a processor, a sub-processor. The only hope I have for these AI regulations, especially the EU AI Act, is I'm looking forward to 5 years from now when we all understand what this means. But in the meantime, what I've discovered is if you reach out to any of the big law firms, they are going to liaise you with somebody in Europe who is far more versed on the EU AI Act, given it's a European law. I think that's very reminiscent of what was happening with GDPR, which isn't always awesome because they're giving the European perspective rather than, I think, the US based perspective as to, what is reasonable to comply with and where can we accept some risks. So I think one of the things we could dig into if folks are interested is just the basics of the EU AI Act. But again, I want this to be like a discussion. So if there's any questions, I want people to raise their hand and just jump in. We can brainstorm. Yes, go ahead.
I'm more interested in the US laws that regulate the chatbot as opposed to this EU issue. Context for me, and that's becoming very real, is in healthcare, we kind of narrowed our limits to, the US only for some of my organization. And a lot of my customers are very interested in augmenting AI into their product. And the question has come to me is, what do we change in our terms of services, privacy policy, whatnot? How do I start from there? And it stems from what product they're using. And there's a variety of product that I just can't wrap my head around. Like the marketing team is using one product versus the engineering team is using, another product. And that's where my brain kind of explodes.
I think that's a pretty common place to end up. Hi, everybody. My name's Christian. I'm an attorney licensed in Texas, and I've been looking into AI stuff for about 2 years now. I do some coding of my own and building my models, but I've spent a few months kind of looking at the AI EU regulations and thought about from that exact perspective that you're talking about right now. Like, does this even apply to me? Do I need to be worried? And something that Laurel and I and a few others have been talking about in some of the messaging is how quickly it's becoming hard to determine, is this product just a US product, or is it a product that's going to cross lines that's going to trigger these other laws, right? Because you have so many different pieces of the product, whether you're talking about the foundational model, right? So if we're talking about ChatGPT's foundational model like GPT-4, or if you're talking about something like Llama 2, and see just with that, if your head's already spinning with just the names of the models and everything like that, I think that's where a lot of us are. And so, to kind of approach it, I think one of the things that would be helpful, and I can get with Laurel and try to put this together, is to try to get a framework of just how to think through these problems when they come up, because I think we're going to be going through this process over and over as you scan through all of your clients' businesses. And it's going to continue to change on a weekly, if not monthly basis, because of the way everything is developing so quickly. And let me just give you an example. I bet almost all of our clients currently use Zoom. AI is now incorporated into Zoom if you don't turn those settings off. That means it's in their meetings. That means it's in their calls with their clients. It's in everything. And that is a model that is potentially subject to the AIEU Act. And now you could be classified as somebody that is distributing that model. Those are the types of issues that you have to start analyzing. And as a US provider, that was not something you had to worry about at all until the AIEU Act came around. And so I think, maybe that's where we start, Laurel, is trying to put together a framework of how do we need to think about this every time we have a new product.
Yeah.
And there's some touch of machine learning or AI. What's the thought process we need to run down?
And I think what's really important about what you just said is, like, I don't know that, given this is very similar to GDPR and the like extraterritorial effect that the EU AI Act is going to have. Like, if you are putting something out there that any person in the EU could leverage or deploy or use, I think you're subject to that. Now, I'd be curious if you're saying healthcare and you really truly are confined to the US. I think that's probably very unique. I actually don't think most of us are going to have that benefit. I think most companies have a European presence in some way, shape, or form. And so because of that, I think we're all going to be subject to it. So I don't know if you want to comment on that aspect.
I mean, I guess what I would be interested in is just a foundational unless the foundational is based on EU, because they're further ahead with regulations. And I can tailor that to the advice of,
Yeah,
my client.
Yeah, so I think I did send along the Council of State Governments list of, and it's outdated in that it's from December. I did send it along from, it shows all the pending bills on the US side. I won't sit here and say I've dug into it personally, but I do know that a lot of the themes are similar to what the EU is going to require. Ryan.
Yeah, Andrew also dropped a tracker in the chat, which I find pretty, at least easy to use. And like, I think one of the things is we're all talking about AI as this big umbrella term, and a lot of these state laws address specific components regarding AI. So it could be algorithmic bias, it could be sort of like the video, what is the one in Illinois? Like, I'm just looking at different ones. Like, there's no like general application AI laws that I'm kind of seeing pop up on the US front, but they all have like very individual applications that may or may not, depending on the product you're analyzing or the vendor contract you're looking at or whatever you're analyzing, like whether or not that would apply. So it's obviously complex. Andrew, you're going to say something.
I think one Illinois law you're thinking about is BIPA. Can't remember what it stands for, but basically the
biometric law here in Illinois. You mean?
Yeah, Biometric Information Privacy Act. But what I've noticed for the states is those that have spent a lot of time creating privacy laws over the last 4 or 5 years are ahead of the curve with creating these AI laws or drafting these AI laws, and whether they are looking to import them into the existing privacy law, like California, for example, with its privacy law is proposing regs, But the other state legislatures are, I think, mostly keeping them separate, but they are the ones that are most involved. And in my talking with people who have helped with drafting state privacy legislation, et cetera, and advocated and all that stuff, that's their experience too. And they are looking at the EU AI Act with like the concept of developer, deployer, et cetera.
Yeah.
And so, that's kind of informing a bit about what Laurel was speaking about earlier, for how knowledge of that, which doesn't have to be detailed knowledge of that, but just the kind of concepts, because they migrate over here.
Yeah. I think we're going to start to see a lot of what I'm seeing with the US laws is that the EU AI Act is far more comprehensive, but a lot of the elements you'll see in some form in this US. So transparency is going to be a really big concept across, I think, all of the laws. That's a big theme, at least that I'm seeing, which in transparency, it seems like it means a little bit something different to every state and in the EU. But I think at its core, it's about, do people know that they are interacting with AI, or whatever the output is that they are receiving came from AI? To what extent it came from AI? Was there a human touch, a human element to it? That seems to be a big thing. And then the requirements around that, I believe, become more strenuous if the more you go backwards in the chain. So there's a user, there's a distributor, there's a deployer, and a provider. And a provider has the most stringent requirements. But I think what we've seen is in the US, there hasn't been a comprehensive law that's addressing all four of those components. Some states are addressing the deployer sort of role in this. There are some states that are addressing only the providers, basically only the chat GPTs of the world who are truly creating something. And then there are some that are, carving out even back further to say only if it's in a certain context, like a consumer-based context rather than a business-based context. So I think that's just staying on top of it. For me, I think I'm taking the same approach I've been taking with privacy laws, which is I'm to GDPR and I try and figure out where there's more stringent requirements or there's unique requirements, in California, in Canada, in those areas. And I'm kind of hoping with the EU AI Act, if we can comply at that level, hopefully hitting my compliance marks with 80% of what's going to come up in the United States. And to the extent that we don't, we'll address that, as they arise. But I don't think anything's been passed yet in the US. Is anybody aware of anything that's passed? Any states that have actually fully, like it's going to go live next year?
I don't think so. I need to check the updated tracker, but I wanted to one, echo what Laurel said. I mean, I think one of the things I'm encouraging my clients to do is just rethink privacy, right? Go back and rethink your privacy and data strategy. Let's do a reset now before we have to later. Let's start thinking it through. You don't have to have all the answers today, but you got to start thinking through the components and the different labels and what it could be. And I think that's probably where I start, whether my client's international or just in the United States, that's where I'm starting, period. And the truth is, guys, for anybody that's working with this stuff, you need to rework your database anyway, probably, depending on what structure it's in and what format and how well it's been kept over the years for it to be useful for artificial intelligence. So you're going to see a convergence of both IT wanting to do this and legal wanting to do this to try to get in front of it before these things come. And the other thing I was going to add is there was a congressional research service report in May of 2023. So it's a little bit old now, but it has a really good just overview of generative AI and the different types of models, and then kind of how Congress was thinking about it back then. Obviously, we've had a lot change in the last year, and they're taking in a lot from what the EU is doing. But I will make sure we circulate this and a few other resources to everybody here These are just things I've collected over time and kind of put into my knowledge base, but I'll circulate that for everybody. And if you guys have questions, don't hesitate to ask.
Ryan, can we set up a Notion page so that way we can share materials or something? I think
Yeah.
that might be helpful, right?
Yeah, we can.
Just because I know we all shared a bunch of materials and I don't want to share anything anybody sent with me if they don't want it shared widely with the group, but at the same time, if people want to share it by all means. Sorry, Rachel, go ahead.
Oh no, you're totally fine. I don't know actually if you all can access the link I just shared. It's and I don't know if other folks are members of TechNet. We are members of TechNet, and that's the TechNet tracker. TechNet, for those of you who don't know, is a lobbying group ostensibly, and they are very good. I mean, they have many subject matter experts tracking legislation. I'm not aware of any comprehensive AI law, but lots of states have passed AI task forces, and we found that to be, for those of you who have the resources or clients who want to spend the resources to influence legislation, that seems to be a good time to write a nice letter saying what your position is, because people on these task forces are sometimes amenable to listening. So that's kind of what I've seen. That's the trend that's passed, is lots of states have task forces or have implemented something relating just to government procurement, but not a general AI law. Like
The other one that I am watching, if it is relevant, is Canada's AIA. What is it called? I never remember. The Canada's Artificial Intelligence and Data Act, AIDA, sorry. That one I'm watching closely because it actually has criminal penalties associated with it, related to like anything that's done with knowledge or was reckless. I find that to be a little intriguing because I don't know that we've seen somebody reach into sort of the criminal side, with that, and I don't know what that means. I don't know obviously what they're going to be looking at to determine whether it was reckless or whether you had quote unquote knowledge. But I do think it's important to bring up with clients, because I think we've all been there with clients who are like, at least in the privacy landscape, who are saying, hey, I'm willing to accept certain risks. It may become you can't accept those risks without the potential of criminal, recourse, so to speak, in certain jurisdictions. And I would just want to make clients aware of that so that they're going in fully informed of the risks that they're taking.
Harrison, I don't know if you want to chime in. I just saw your message.
Yeah.
I think everyone's now reading it.
Yeah, sorry, that was bad timing, I guess. It went quiet. Basically, just like, this is all great, and it's just when clients approach me and they're like, look, I'm cash strapped. Like, how do I prioritize? I'm triaging everywhere, including with legal. And so oftentimes I tell them, I'm like, look, if you're super cash strapped, look at a competitor in the market who presumably has spent quite a bit on legal, and see what you can glean from their external facing docs and their approaches there, and just follow that. Because as long as you're in the herd, presumably the herd is either in the right direction, or there are so many of you that regulators aren't going to come after them until they're a big enough problem. And they're either a big enough problem because they're a successful company and they're large, or they have enough user complaints. And then in that case, I tell them, always be responsive to any data subject requests, so that any user complaints, just be super responsive. So if you all are aware of any like gold standards that clients can emulate, that would be great.
It might
I haven't
be tricky.
seen any yet. No, I was just gonna say I haven't seen any yet. And in my full-time job, I'm in a weird spot in that we are very much a startup. We are very cash strapped in the way that we operate, but all of our clients are Fortune 100 businesses. So from a compliance standpoint, we have to operate closer to a Fortune 100 than a startup. Not saying we do, but we have to sort of manage, the expectations because it becomes a major problem for us from actually getting business to sign on. And I don't know how others if others are starting to receive requests from their clients, but I know that I'm starting to get like requests to amend contracts to address AI and those sorts of things, which has definitely been very difficult to address in a universe in which we don't know is going to be required, what is going to be required right now. Go ahead, Brian.
No, I just think there's so many variables right now. I mean, I think we're all talking about clients as well in like this abstract way, like clients or employers or whatnot. Like AI is being used in so many different ways. Either it's a vendor or you're actually deploying it under the hood with your product, or you're creating some version of, or SKU of AI with OpenAI as your backend, or some other model. Like there's all these different ways in which you could be using or deploying, or what, I don't know all the terms that Laurel that you said, but I think that makes it tricky, Harrison, if you're advising a startup and you're looking at what other startups are doing. It's really hard to know what's actually happening under the hood. To what extent are they just incorporating some other version of AI, or you're using an AI vendor versus building their own? And I think with privacy, it was very easy to do that. Like look at someone's privacy policy and copy that. Very difficult, I think, in this circumstance, because there's a lot more restrictions on practice versus kind of like disclosures. I mean, a lot of privacy laws are mostly pretty heavily
I think
regulated.
that's changing. I think what we're going to see is next year, you're going to start seeing everybody have an AI policy posted the same way that they have a privacy policy posted. The question is going to become how visible those AI policies are. So like if you don't have any AI features on your website, it's all built into your product, you may not see that AI policy until like you're getting to behind a paywall. But that seems the transparency aspect. The only thing that they've advised, practically speaking, is that it's going to have to be transparent, like a privacy policy is supposed to be transparent, and that will be your way of complying with transparency. So I don't know whether that's a separate policy, it gets baked into the privacy policy. I think all of the structure around that is TBD, but I do think, Harrison, your point, in the next 12 months, I'm hopeful we'll start seeing some examples of what that's going to look like.
So let's pool our funds together and we'll get behind a paywall. We won't ever use the service. Let's just get the legal terms and dissect it and see what's in there.
Well, and along those lines, so I have started to put some together that I've gathered from some different platforms, and then just some things that I've gathered working with some clients and stuff. And I'm happy to share that. It is not a complete product at this point. So obviously all the normal waivers and everything else, but I do have some things, that we're starting to see common patterns of types of disclosures related to AI being used, and then a lot of things that we're starting to see changes with the data processing addendums. We're seeing a lot of those being added to agreements that are specific to how the data is being processed, who's processing it, what third-party vendors are being used. So I don't have all the standard language, but if you are struggling to try to figure it out, I can probably help you get you started and point you in the right direction. Just give me a shout on here, or give me a call.
Cool. Awesome. I appreciate that. Thank you.
Go ahead. Somebody raised their hand.
So I'm hearing a trend of what laws we should evaluate AI, and definitely privacy is one of them. And so is maybe data processing and how you sort through how that data flow is. Question of how did you think about the ownership aspect of the data? Like right now I'm struggling to kind of negotiate with my vendors, who owns the data. Like, of course, if my data is incorporated into it, I want it all to belong to us. Have you guys seen that approach? I mean, some sort of approach, some kind of leg to stand on, so I could standardize something when when I talk to my clients to kind of think about AI concerns, just throwing it out there. That's one thing I'm struggling with on that piece.
So I've been equating this to the aspects because I have to keep like comparing back to GDPR because I think it's helpful because we know how the EU thinks about the GDPR now. So if we can apply that logic, I think it just helps us to be able to understand what they're getting at. So what I think part of the expectation is going to be similar to the concepts of pseudonymized data, anonymized data, de-identified data. And I do think we have to look at it through that veil. So if I am sending an inquiry into a chat GPT that is, hi, can you explain this concept to me? That's not really my data, probably, right? No, I think you could state that that this is where the de-identification comes in. They should never be able to state that I asked that inquiry, that it could come back to my company as having been the one that asked that inquiry. But the response that I get back and the input, the fact that somebody else may also do that and they may leverage my response to perfect the response, I don't think I think I can be comfortable with that. I think when you get into what I'm going to consider more like locked down AI, so I'm thinking like contracting tool that's leveraging AI, I think that that's where I get a little bit more uncomfortable, right? And I go, I don't want you leveraging anything that I've negotiated except for me, right? Like if it's training AI in a way that I can then continue leveraging that, that's great. But I don't want it being leveraged for, third parties, so to speak. And I do think this becomes like a case by case analysis, and you have to figure out like what the buckets are from a fact pattern perspective. And I think there's probably like three buckets. There's like the fully permissive bucket of I don't care, you can take it, just de-identify and don't make it mine. Then there's the in between that says, well, you need to de-identify some, but for the most part, there's stuff you can use and stuff you can't use. And then there's the third most extreme, which is you can't use anything. And you just need to figure out what the patterns are that go to that for you and your company.
So I'm going to go back to healthcare. It would probably be HIPAA. Like if it's sensitive health information, has any of the 17 identifiers, that's probably like where we stop the line and say we can't incorporate that and own that data. That belongs to the patient or whoever the covered entity is. Okay, that makes sense. So, okay, maybe perhaps I just leverage the applicable laws to my organization. And whereas you are a global company, you apply GDPR, maybe I just apply HIPAA to
It's a good starting point for right now.
It's also like an obligation you have, right? I mean, you have to enforce the HIPAA on your vendors no matter what, right? So that's I don't see this being, and maybe this is overly simplistic, but the analysis to me when it comes to the data sharing and data use is very similar to all the things I negotiated on the commercial side with all the new privacy laws. And
I think as a user, that's right. Like if you're a user, that's what you should just be looking at what laws apply to you.
Mm-hmm. Yeah.
Like if you're just purchasing, that's the way I would look at it.
But not just the laws, right? I mean, your commercial interests. Like you don't want another company like training a model on your data, because that is, if there is some sort of proprietary value to that data and the knowledge that you're sharing, like, and even the knowledge that they're helping you figure out, that is still something you want to protect because that's your competitive advantage. So I think, if you don't have, if you're really just trying to get answers and that's that, like, I think it's okay. But if you're creating kind of new knowledge with the help of AI, you don't want to just give that to the rest of the world. And so I think about that. I mean, when I was in-house at Blend, a lot of banks were pretty fierce about what we could do with their data, even though we weren't doing any AI stuff, but we would use data to, make our products better. And even that, you would think would be table stakes, but it's not. Not when there's a big bank saying, don't use my data to make your product better, because then you make everyone else's product better and we lose our competitive advantage. And I think the same thing applies to AI. So
yeah, and Brian, there's an important caveat there that I think you hit on too with this product in particular, because we're dealing with generative AI, right? So we have an input that is our data that we own, that we control, but the output that comes back out that you get is something new. It's something that's created. It's a new data. And if you look at your agreements with your providers, you don't actually own that output. You have a license from them. It's usually, I was looking at a clause a minute ago, it's usually a perpetual, irrevocable, non-exclusive, worldwide license, but they actually own that. So whether you're talking about, a ChatGPT or Anthropic or whoever, most of their clauses, if you go look in those terms, they own the output. They're just allowing you to use it, and then they're agreeing to certain restrictions on how they use it. I think that was kind of what you brought up in my mind, Brian, is depending on what your client is doing and what the data is that input is, you really want to clamp down on what are those restrictions. And a great example was with like Azure AI and all the enterprises that are starting to use that to get access to different models. A lot of enterprises have PPI that they can't have exposed, right? You wouldn't put it into a chat GPT, and they're counting on these enterprise models to have that protection. There was just an article last week that I read where, despite the term saying that they don't collect any of your proprietary data if you have certain settings on, they still have a clause to collect that data for 30 days related to abuse of the system, and they do actually collect it and store it, right? And so for some clients, that's not a big deal. For other clients, that's enough to say, okay, I can't use this platform, right? Or I have to have them turn those abuse protections off for my particular data because my client will not be comfortable with that, especially for law firms that are using legal products, right? So things like that, I think, are going to be the things. If you focus in on the privacy and data protection laws that apply in the United States today, and then you say, okay, based off of that, what are the products that am I using that have AI, and how am I using them? I think you're going to find that it's going to be easier to back into than you think. Where it gets tricky, as Laurel pointed out, is when you're starting to make your own models, when you start distributing that on a platform, either in the States or overseas, or you lose control of it and you don't know where it's going and you don't have compliance systems for that. That's really where I think the big risk is. And we're even seeing in some of the new language for the AIEU exceptions for like open source models and companies that build on open source models, because they don't want to stymie the development obviously in the space. So it'll be interesting to see kind of what that final language is and where those exceptions fall. But I think, I don't want to say it's a common sense approach, because I don't think anybody feels that way about the GDPR, but I do think it is a common approach towards how the GDPR has been applied. And if you can attack it that way, you're going to be more in front of it than most.
I think to add on to what you're saying is, I'm of the opinion you can take a common sense approach to this if you are a deployer or a user, because I think most of the heavy regulatory requirements are coming under the people who are providers, who are actually creating AI and providing it in a paid format. The deploying one is a little bit interesting because I consider that like an internal use case, right? So like, let's say you have an internal Slack bot for your employees to use, and you just purchase that from somewhere. Again, you are subject to the transparency requirements, but the transparency requirement is your employees need to know that they're interacting with an AI chatbot. As long as the thing says this is an AI chatbot, you've kind of met the requirement. So like, it's a common sense approach there. On the provider side, I think it gets really messy. And I know that I'm starting to have conversations with customers because we have a roadmap of AI features that we want to build. The first use case is a support-based use case where we want to build a Slack chatbot that's based on AI that customers can go to and say, hi, I ran into error code X. Can you help me? And of course, there are a bunch of highly regulated customers that are like, well, I don't want you learning. I don't want you training. I don't want you leveraging that. And the question, of course, I have is, well, this goes to the ownership issue. We're talking about input and output. And I'm going, well, look, I understand you own the input in terms of the way it's phrased and everything else, but like you don't own the fact that that error code exists. You don't own like the answer that's going to come back that's going to be about our technology, right? But we want to be able to train the tool that as the customers are experiencing certain issues, the tool gets better at addressing it, so it's less likely, so that way we can be faster in responding to our customers. I do think some of this becomes, again, trying to really fully explain that to customers. I do think, though, if you are in a customer facing scenario, if you are the vendor in a customer facing scenario, I like be very leery about the requests you're getting from customers. So I got an amendment last week that if you read the definition of generative AI, it would prohibit a calculator. It said anything that when you put an input in, you get an output out of. We had to send a response to them that said, that's a calculator. Like you realize you just prohibited a calculator if we sign this. And so I do think just to be really leery about that. And that is where I am starting to leverage like the EU AI Act and saying like, hey, can we at least start to use some common definitions that I think are going to be accepted across all industries? Rachel just shared something.
Yeah, I just shared, I don't know if any folks on here know Phil. He has a firm, Digifile. He used to be at Field Fisher, but this may just be overwhelming to some people, so you might not want to look at it, but it's just his distillation of how high-risk providers, what high-risk providers are going to have to do to comply. And
Yeah, Rachel, can you break down that entire graph right now for us? I'm just kidding.
Yeah, I saw that a couple days ago and was like, okay,
yeah,
tabling that for now. I'm going to look through it later.
Yeah, I mean, my primary client, HireView, is going to be a high-risk provider, and so we are already starting to one, get lots of questions from customers, and two, figure out how we can leverage existing documentation to comply with the transparency requests. And we already have third-party audits, we already do like ISO, we have like, how can we leverage all of the frameworks that we already have in terms of InfoSec and privacy to comply? So we're in the trenches.
I think that's really it. It's a great point, Rachel. I think the one thing that I had found really interesting, and it was buried in some of the advice, I don't think folks have been focusing on it. So I've always worked for what I'll call non-regulated companies. Like I don't work for fintechs or health techs or most of the companies are like security companies, right? And they have like cybersecurity principles or just general regulatory requirements, but they're not in a industry that quote unquote makes them high risk. But what is very unknown right now about the law and a little scary is that they're saying if you have customers who are in high risk contexts, that can make you a high risk AI if it's being leveraged that way. So like, if I'm selling to healthcare companies, I don't know what brings me into a high risk context. Is it the one healthcare company? Is it 10% of my business, right? Like nobody knows what that threshold is. And so I've been talking to some people and saying like, you do need to start looking at the industry breakdown of your customers. And I think if you're looking at a customer base where 50% of them are regulated, you should probably be approaching it as if you yourself are a regulated high risk industry, because I think you're going to get roped into that context, sadly. All right, checking time. Is there any other questions?
Since you're talking about risks, has anybody explored what your insurance premiums becomes if you're providing AI, because I'm getting killed in cyber for my company. And I haven't told, my insurance company we're thinking about providing AI. I mean, we haven't explored that with them. So I'm just trying to see if anybody during renewal has talked to, on behalf of their company, talked about insurance and in premiums. No, okay.
Just trying to get my company wrapped around regular insurance policies right now. We have not started digging into that.
Yeah, the beauty of my company is they do listen. They understand, like, healthcare breaches are all the time, so they do pay attention to that. It's just now that we're doing AI and trying to put out a product, the first step is, changing our privacy policy, changing all that. And then the next step is just getting insurance to cover for the unforeseen. So I'm just curious about the cost. I'm kind of scared.
Sorry, I was on mute there and I was struggling with that. Yeah, so our cyber, so we have an AI product, and for our process with the insurance carriers, I think the cyber will go down to just, the cyber is triggers, you guys probably know, is like how many records you have, and like it's kind of what they look at like how many data elements are there in your database. So like what's the extent of a data breach, right? So unless your AI product has probably exponentially changed your data sets or risk of PII being breached, or you have more PII, then that would increase your cyber because your product now collects more data, right, inherently. In terms of the business model, I think that would fall under your is it the error? I think it's errors and emissions. I think it would be the line it would go. Obviously there's different business lines of insurance. So I think it would be probably the insurance that covers your business model and generally, which I think is errors and emissions. So you probably
Or product liability?
Yeah,
Does product liability?
I think product liability may roll into errors and emissions. I can never figure out all the different.
It probably depends on the insurance provider too. I've seen it both ways.
Yeah, so that's so I would think. So I think you probably see it in the other areas of your lines of insurance, because we haven't seen an increase. I mean, we've seen an increase in our cyber just kind of inherently, right? But just because costs go up, but not one specifically because of AI. Although we are going to be going into our renewal again, so we'll see what happens. We go out to the market.
Is it because your AI product is limited in the data it collects, or do you legal like limits what kind of responses you
Yeah, so like, I mean, the AI product collects PII. So yeah, but it's not like it's exponentially more complicated PII. It's the same PII that you would have collected in another channel, like name, address, stuff like that, right? So it's not like it's collecting. Let's say you had an AI product that just collected a whole new dimension of PII. Like, we're not changing the dimensions of what we're collecting. It's just being collected in a different product.
Well, that's helpful for me because I could at least tell them, let's not expand it to PHI, because number one, you can't control it. So I could tell my product when they're developing, can we just limit it to PII and maybe.
Yeah, so I guess I would, that's sure. Like, but I think yes. I guess my only hesitation is people will say, well, it's all about generating revenue, and insurance premiums are smaller than revenue, hopefully. So if you can generate more revenue, maybe they go that route. But that's the cynic in me.
Okay, thanks. You've given me more ammo than I need.
The only thing I'd add just to Brian's comment about the banks, I think it's important, like we're talking about this, is really understanding your business model, like, and also the business model of your vendor. Like, that's, I think when we look at these relationships, because in a prior company we had a give to get. These are like AI seems like a give to get business data set model, right? So we had a really big, robust give to get model with almost all the leading banks, and they gave us our data and we gave them outputs, and we got to keep the data. But that was because they saw the value, and they understood the business model, they understood what we were giving back. So I do the advice I would give. A lot of these, like, it's kind of Laurel's pointing out, is a lot of it's common sense, right? It's just kind of common sense, licensing issues, data issues, just applied into AI. But I really would stress understanding your business model and your vendor's business model and your customer's business model. And then I can share also, we just got from one of our customers, kind of like it's not a SOC audit, but it's imagine a SOC audit about AI. It was like, so what we're going to agree to going forward in case they want to make sure that our AI principles are actually what we're doing. And so they gave us kind of non-negotiable terms, which I'm happy to share. People would find that helpful.
Yeah, that'd be cool.
So I can kind of cut and paste that and send it around. So
Thank you.
So just Nick brought up a point that's reminded me. So for those working in the banking sector, especially anything with open banking in any capacity whatsoever, the CFPB's proposed rule on that placed extreme restrictions on any ability of a party receiving a consumer's data to reuse that data for anything but the existing product that the consumer is actually requesting. And there's numerous pushback on that, et cetera. But as far as the use of AI and what data you can use, a lot of data privacy laws will impact that. There's data minimization requirements and all that type of stuff in state data privacy laws. And from the federal perspective, though I imagine the CFPB might be challenged if they actually go through with that, there will be, or there very well could be data restriction usages on what you can do with people's data. So just be aware of that.
I do think that's a great point, though, because it does go back to the GDPR, right? What I'm curious about is whether data processing agreements and addendums are going to morph into the DPAs that we know today, but include AI aspects to it. Because I do think you're going to have to get the right consent and permissions and all of that. And it's going to be, you're going to have to be negotiating more than maybe we have in the past. At least my company certainly has in the past, where our stock standard position was usually for the purposes of performing the services. But I don't know that I can argue use of training an AI tool is for the purposes of performing the services. And so I think you're going to have to start detailing that out, at least to the extent there's personal information involved.
Laura, you don't think that'd be picked up in kind of a standard, improvement of the product clause? Most privacy policies allow for that. Use data.
Yeah, I mean, I don't know. I think that's the question as to whether, I think this is where like we're all going to take an approach, right? Maybe we're going to say, yeah, it's covered under these standard clauses. It's covered under, our general improvement to the software clauses. I think two things are going to happen. One, we may find that customers want to negotiate those far more than they have in the past, right? In which case we're going to have to get more granular from a playbook perspective as to what we actually need versus can live without. And then two, I think it just comes down to the regulators and whether they consider that transparent enough, right? If it doesn't meet the transparency requirement, I think that's where I'm trying to figure out is what is transparent enough without being too transparent that it basically invites my customers to negotiate.
Yeah, and that's why I brought up the open banking rule, because that concept of product improvement it's very unclear whether that would be included within the permissible use that the CFPB is proposing. And if it's not, then, which I mean, that's a lot of the pushback is like, hey, we're using AI to help build this product, to help, abstract away and identify what are trends that are good or bad for consumers, et cetera. The CFPB is very concerned about re-identified data, which is a portion of why they're proposing or trying to limit it. But that's the main reason why I brought that up is I don't think the existing improvement of our product is a sufficient use case if you're getting data from banks via open banking rules, if the CFPB finalizes it. So it's only for that people in that industry. So I just want to make that clear. But a lot more people will be in that industry as they embed finance into their products for various things.
Is that AI or PII or both? Like, is it PII that's gotten through
It's
AI?
both. It's whatever data you get from the consumer to provide. Like, so, like,
No,
just think of like personal financial management. You link your account to your city account,
Mhm.
and the data comes through. The entity providing that PFM tool can only use the data to show you what your finances are at that time. They can't use the data and abstract it away to come up with, hey, people in this income bracket or people with, this type of debt, this type of whatever, and use that to kind of come up with a model to help you better manage your finances. Or maybe you might not be able to. It's not 100% clear what the CFPB is trying to do there. And so we'll see when they release the final rule what they further say about that.
I've always wondered what they're trying to do.
Yeah. No, it was unexpected to some degree that they came out that aggressive, and there was a lot of pushback in the comments. But yeah. But AI, I think, would be included within that if it's to help, quote unquote, improve the product.
So you couldn't use PII to improve a financial product. Okay.
I think like
That's what they're saying.
that to improve the product, like that allowance in certain contracts has been or was way more harmless 5 years ago than it is now, in that improving kind of like maybe let's say 8 years ago, but improving like a SaaS product based on interactions with your product is kind of like table stakes to continue to improve things and make better technology. But now that like a lot of these products aren't just selling SaaS or like workflows, but they're actually selling knowledge to a certain extent, then it starts to become like by licensing or giving the data for that specific purpose, you're granting more today than you were 5 years ago or something like that. You're granting a lot more power and a lot more knowledge of whatever your consumers or your business or whatever. And so I think there's probably going to be a lot of changes in how that's like how nuanced that grant of data is. Like there's probably it's probably that one clause is probably going to get broken up into like 5 or 6 different things potentially. So I don't know. That's kind of how I'm thinking about it. It's like maybe we just need to get more nuanced in how we're drafting these contracts. We do have 3 minutes.
So don't know. Yeah, I also don't know though, Brian, if it's even in the contracts as much as it's in the product design, right? Like to say this is all configurable, I feel like it's like a privacy by design type of concept, where in your settings for the product that you as the user, like there is all these options that you can click that are like on by default, but you say any of this can be disabled. And so you could say like, obfuscate any personal information that gets sent through, you can use the inputs, but only to the extent the inputs don't include, things that look like names or socials or banking info account numbers, right? That sort of thing, and put it at that level. And I kind of look at it the way that ChatGPT has like the thumbs up and thumbs down that you can click to tell them it's good or bad. Like to basically at a product level give users the ability to say like, I'm okay with you collecting this information and using it, but I'm not okay with you collecting this information. But that then I think goes to the product design even more than the contract at that point.
Well,
right?
on the commercial side, I'm more thinking like if there's a clause that says you can use the data to improve the product, right? Improve the product can mean a million different things. And maybe like to what Andrew was saying, like I would be okay as a consumer or maybe even as a business that you use the data to improve the product's ability to show me how to analyze my financial spending trends and give me tips. However, don't use it to improve the product's ability to market to me. Like that, like those are 2 different uses to improve the product, but they're both very different. And one is a little bit more sinister maybe, and one is a little bit more helpful. So I don't know, maybe if I'm drafting a contract and I'm using a vendor to do some of this stuff, I'm like, you can use this to improve this part of the product, but not that. but it gets really difficult, right? Like, how are you going to enforce that? Yeah, no, I hear what
Yeah,
you're
and I
saying.
think
Like, yeah,
I was just gonna say, Brian, I think a wrinkle of that too is as your clients or your customers are starting to use different models, as they start putting in data and documents to those models, and basically that model starts fine tuning or training itself or using some type of retriever for that information. You mentioned before that, that's a new knowledge base, but that's also an entire new set right there of data that you got to figure out what access you want them to have and what level of training. Like what I'm seeing in a lot of the agreements at the enterprise level is they are allowing the models to train on that for their purposes, and their model can iteratively train as they work through it, but it can't be used by any of their other clients or for their general model purposes. And then there are some clients that are already negotiating away their data, right? So they may be using the service and selling data back to them, both the output and some inputs. We just saw the big Reddit deal happen this week, and I think that's going to be a snowball effect through the rest of 2024 as data becomes really, really important to everybody all of a sudden.
Well, we're at the top of the time. I want to thank everybody for participating. This is really great. I think, Brian, we can sync up. We probably will want to do something, I don't know, at least quarterly to like stay in the know about what's going on and hopefully find other ways we can collaborate as a group as we all struggle our way through this.
yeah. And if you have any tips on what we can do as we have a collective group of minds here, people who are thinking about this stuff. Maybe it's like a database of just things that we're all sharing, tools, a shared doc, whatever. I'll try to put something together with the help of people who volunteered some materials. But if there are other ways you think we can combine forces, please let us know.
I think the Notion page is genius because it gives you so much functionality there, and I think everybody is starting to get comfortable with there. But that's just my opinion.
Yeah, I second that. And thank you very much, Laurel and Brian and everyone for organizing this. It was very informative.
Oh, Laurel. Yeah. Thank you, Laurel.
Anytime, guys.
Thanks, Laurel.
Thanks all. Bye, everyone.
Bye, everyone.
Yeah.